My name's Mark Johnson. I'm a Superior Court judge in California, a retired Army colonel, and I've teamed up with retired Army Command Sergeant Major Gregory Coker, and we're here to help veterans. Hi, I'm Judge Mark Johnson. Welcome to Reaching New Heights with the Judge. Just me today. Sergeant Major Coker is helping a veteran get into some good, clean, safe housing, and I have no doubt he's going to accomplish that mission by the end of the day. That would be his track record. We're going to talk arraignments today. I'm trying to educate you, the veteran, or you, the loved one or family member of a veteran, to make you more powerful as you go through that courthouse door. I'm not giving you advice on your individual criminal case for one good reason. I don't know anything about your individual case. And also, I'm not allowed to do that as a judge. But let's talk arraignments. An arraignment is the first hearing in the criminal process. The purpose of an arraignment is to formally notify you of the charges that have been filed against you by the district or the state's attorney or the U.S. attorney. It puts you on formal notice of the charges against you. Another aspect is that the judge will, after reading those charges, will then inform you of your constitutional rights, things like the right to confront and cross-examine the witnesses against you. And then finally, the judge will ask you, or should be asking you, whether you have an attorney, whether you can afford an attorney. If you can't afford one, the court should be appointing either a public defender or some other county or state appointed attorney to represent you. So those are the basic aspects, the nuts and bolts of what an arraignment is. But I want to talk about three things why I think arraignments are very important. Arraignments are often I think it's under-examined part of the entire criminal system. I will confess that when I was a public defender and I might have 50 arraignments on one day, I didn't spend a lot of time on any one, probably because I didn't have that time. As a judge, it might not be unusual for me to have about 200 arraignments on in one day, depending on the type of court I'm presiding over. But I think arraignments are very important, and the reason I say that is there's some critical things that go on there. And let's talk about the first. The first is the setting of bail. Unless you were brought in on an arrest warrant signed by a judge, the judge, is going to set bail for you on that day. The first stop for that judge is probably going to be a county bail schedule where bail is set for each type of offense being charged under our California Penal Code. That's going to be the first stop. Judge is likely to set the bail. Let's say the bail schedule says $30,000. The judge is likely to set the bail in that amount. But you can challenge this. And this is where we get down to some basic principles, because one thing I will tell you is that the bail that is set at arraignment tends to stick with the person charged with the crime throughout the entire case. Yes, it can be changed at any time, but that amount tends to remain in effect throughout the whole case. And secondly, here's the other main principle about bail. It's a lot easier to defend yourself if you're not looking at your attorney through glass, listening on one of those little shaky telephones that seem like they never work all that well. Speaking from experience, I've used them thousands of times when I was an attorney. So ideally, what I'm saying is that you can defend yourself better if you're out of custody. I believe would be the general rule. So, if through an attorney, or you yourself, although I would suggest an attorney, if through your attorney you're challenging the amount of the bail schedule, perhaps you want to be released on your own recognizance, or a far lesser bail, something that's more affordable for you, the court's going to look to certain factors. there's some compelling interests that the state has. The first is to make sure that you show up in court. The second is to the protection of society and the victim in the case, if there is a victim. If it's, in most cases, there is some form of victim involved. So those are the factors the court's going to be looking at. Now, but here's what was happening, and this is why there have been movements to change this. It's been starting about 5-6 years ago. I've seen it. All these lofty things: protection of victim, protection of society, guaranteeing the presence of the accused at his trial. The problem is, what was happening is the people who had the financial wherewithal, i.e. those with more money, were tending to be released on bail. Regardless of the factors, those who didn't have money tended to stay in custody. And as I said, I think it's a far better situation to defend yourself when you're sitting at a conference table having a cup of coffee with your lawyer than looking at that same lawyer through a glass that's about a half-inch thick. So, a few years ago, the California Supreme Court ruled in a case in Ray Humphreys, ruled that the court must also consider the financial situation of the defendant and whether there are some alternatives that could be used to meet those same interests of guaranteeing the protection of society and a victim and making sure you're in court, like things like some type of electronic monitoring, an ankle bracelet, an alcohol reading bracelet, giving up your passport. I'm just throwing out factors there, but I guess what I'm pointing out is this is what good lawyers do. They start working these factors and convincing me why I can feel good releasing you at a far lesser bail than what's recommended by our county bail schedule. And I can feel like, okay, I've done my job protecting society and protecting this alleged victim in a case. Because we always have to remember one thing. People who are in custody, and at any given moment in the United States, there's about 500,000 people who are in custody pending trial have committed no crime yet in the eyes of the law. So, and remember that one thing I said, that the bail that's set at the beginning tends to stick. So that underscores the importance of doing a good job at the arraignment and presenting your case for bail, a lesser bail, an OR release, things like that. Secondly, your appearance and demeanor. Look good. Now, granted, I didn't. I'm home today. I didn't put on a suit and tie, but that's what I wear to work. I'm not telling you have to wear a suit and tie, although I tell you it helps. And I'm talking comparable for ladies, comparable dress, something that looks professional. But let me just use men as an example. A suit and tie, I would do it if I were you. Am I going to remember everybody who shows up at arraignments when I've got 150 people coming in? No. But I can tell you, I generally remember those people who do that. And if I'm in a court, for instance, where someone will show up a few times when I haven't done veterans court, I will start to remember that this is an individual who's dressed well. And in addition, their demeanor and respect for the court shows through. Most of those pretrial hearings are not times to start arguing your case. But, if you're respectful, you dress well, you have good demeanor, I feel you're showing respect for the court. And I'll tell you where this is really important, is if you go up in front of a veterans court, because often the way these courts work, you have these big arraignment courts. They're just huge. They're masses. They're people talking. They're very confusing. Veterans court, which I preside over, is a specialty court. You may have 30, 40 people in there. I'm going to get to know you as you're coming back for appearances. And I tell you, the veteran who's dressed well, who's respectful, who's also taking efforts already, for instance, getting into classes or programs, by the time he gets to court to address the problem that got him there in the first place, those are important. So I put all that under the second element there, your dress and demeanor. Finally, number 3, I think is important. If you have criminal charges, you have served this country. Even if you haven't served it honorably, talk to your lawyer. Bring those documents. Dig up that DD-214. Bring it to court. DD-214, for those of you who don't know, is the separation document. It's extremely important. It shows your level of discharge and a lot of things that document your service to this nation. Make sure you get those things. Don't come walking in, please, and say, I couldn't find it. I looked, Judge, it's not around. Don't do that. I don't think it looks well. So the three things I think that are really important at arraignment: bail, your demeanor and dress, and your preparation to present a good military case. I hope this helped. And if you got any questions, just leave them below. Sergeant Major Coker and I do not make a cent off of any of this. We do it because we love it. We love you men and women who've served this country, and that's our goal. Helping you out is our mission. But if you do want to help us, please hit that subscribe button. I need some more subscribers. We're still lagging a little bit, so I'd appreciate it. With that, thank you very much. God bless, and keep on moving on, veterans.